Hi, this is a conversation with Chris Horner, who is an attorney from the Free Market Environmental Law Clinic. And Chris, what is the role for an attorney in the environmental environment?
Well, there are several. There are the traditional roles where you can participate in rulemaking processes as agencies implement laws in ways that they think are the best interpretation of what are typically very broad, often sweeping, vague grants of authority from lawmakers. So everyone's voice needs to be heard. You generally have a right to participate in this process, and attorneys are increasingly involved in that from the pro-liberty side to make sure that that voice is added to the rent-seeking community, which is ever expanding, those people seeking to feather their nest due to these regulations, either directly or by disadvantaging their competitors, and the environmentalist movement, or the pro-state, enhancing the size of the state, or the involvement of the state movement. So that's sort of old school. What does a lawyer do on these issues? We've been adding a new practice, which is taking a page from the environmental movement's playbook, which is using open records laws as well to do what our Supreme Court in the United States once wrote in an opinion: find out what your government is up to, because we believe markets make better decisions with better information and more information, so we try to obtain. What are they saying to each other, the agencies, the regulators? What are they saying as they work and often collude with pressure groups? And compare that to what they're saying publicly. Oh, this won't make electricity prices skyrocket as the president promised, and then walked it back. And then privately they say, oh yes it will. Privately they'll say, this won't bankrupt you, as the president once promised. And then, or publicly they'll say that. And privately it turns out they say, oh yes it will. So these are important facts for the public to take into consideration as well when they tell their representatives how the policy-making process should go forth. So we're adding this new twist of trying to get more information out into the sunlight for a more informed public to make better decisions on policy.
Is that a widely used tool for the freedom movement?
No, not yet. And it increasingly is. And in fact, my objective would be for every group in the freedom, the liberty movement to have somebody dedicated to thinking about what information should we ask for, to being trained in how to ask for it properly, to narrowly tailor it, to choose the right verbiage, the right windows of time, to how to look for the records, or how to go fishing, which is permitted under these laws. Every group should have a person dedicated to that, and every group should have access to a law clinic, some lawyers, a pro bono law firm, or a for-profit law firm satisfying its pro bono obligation this way, by representing these groups as well, not just agitators, not just statist groups, but the liberty movement. And that is simply underutilized.
What are the most current issues in terms of environmentalism these days?
There's a blob that has eaten environmentalism, and it's the climate movement. It's the all-encompassing excuse for whatever bothers you. And as we discuss here over these days during my visit, every excuse under the sun has been offered as a rationale for why we need to do it. What bothers you? I've got just the thing. It's energy rationing, though I'm not going to sell it as energy rationing. But it's sort of the brass ring for the movement. It's also a plan B for every failed movement, whether it's zero population growth or just the fallen statists after the wall fell. They tended to migrate to the environmentalist movement. And their big objective these days is the climate agenda. There's an awful lot else going on, and there are numerous components of the climate agenda. It's not always a direct assault. But that really that consumes most of my time, because it consumes most of the movement now.
And from the point of view of a student of law, how do you recommend students of law to prepare for this kind of environment?
Well, I would develop a thick skin Don't go into this to make friends. Find them somewhere else. Be aware, as people in the past have said, that you know you're over the target when you start taking flack, or when they're ignoring you, you may be getting close, but when they begin ridiculing you or attacking you, you've gotten much closer, because that is an inescapable element of opposing this movement. It just is. I live 2.5 hours away from my office if there's no traffic. Why? Because I had lost all privacy. My trash was being removed every week by Greenpeace and put in the newspapers the night before it was to be picked up. I had camera crews, I had people sitting outside, just all sorts of intimidation tactics, and also just it's what they do. And you have to get used to that, be ready for it, and welcome it as a sign that you're being effective. It's so long as you remember why you got into this, that you have a purpose, that you have an ideal that you're pursuing, and it's grounded in liberty, this will fall off your back like water off a duck's back ultimately, but be ready for it, because it really is different than most aspects of a law practice encounter.
Let's go back to the movement for freedom. What are the options for the movement of freedom in these kind of conditions?
Well, you're just going to have to not give up. You're going to lose some battles. You're going to have to explain to people, as you do here, that you won't see results immediately, but this is something we have to do. It is effective. The other side does it. Here's how it has advanced their cause. Here's how it will advance liberty. And so long as folks remember that this is an absolute bedrock requirement of the rule of law, of good governance, is transparency. And that you own these records. They are not theirs, and they decide what to give you. They're yours, and you have a right to them. And so, again, this is something that the other side knows very well, and that the pro-liberty movement hasn't considered sufficiently. And so I would think that adding this to every group's repertoire, most countries have a right in their constitution to petition the government. Add this to your repertoire. The pro-liberty movement has rightly been wary of lawyers for very good reason. We haven't always done the right thing. Lawyers have a deserved reputation in many ways, but they can be of great assistance here in supporting the rule of law, which was, of course, the original objective. And I think the liberty movement needs to bring more lawyers into the fold, train more lawyers, and support them, and make sure they're ready, they're available to all of the groups. Not every group needs this function, a legal function, but every group should have access to it.
Can you share with us a particular experience or an example of a case in transparency, in opening records, that would help our viewers to have a better idea of what we're talking about?
Okay. With the U.S. Environmental Protection Agency, called them EPA, we found a series of tactics to which they turned after running for office on the promise of the most transparent government ever. Why would you promise that? Because people want it. Why do they want it? Because it's a bedrock principle of good government. But then they set about meaning, well, that just meant getting the other guys, the guy before me, getting his records out there. When it comes to ours, we've got all sorts of tricks, beginning with the White House. And this was covered by the New York Times, Mother Jones, left-wing magazines. They would use private email accounts, not the one they were required by law to use, a White House email account, to email lobbyists who they said they weren't going to communicate with, to have meetings not in the White House where you have to sign in and create a visitor record, but across the street at a store called Caribou Coffee. So they'd use private email accounts to correspond with people they said they wouldn't meet with, to not leave a record of the meeting in any way for people who would look for this, where you would look for it, to hold these meetings that they said they wouldn't hold. And then this trickled down through the agencies. We found EPA goes across the street to Starbucks to meet with Sierra Club. We know this from email accounts. What sort of email accounts did they use? False identities. The administrator was named Lisa Jackson. They set up a false identity for her named Richard Windsor. And at the bottom, it did not identify the person as the law requires. So Richard Windsor is corresponding with parties, and you wouldn't find these records if you were looking for them. Richard Windsor carried 2 BlackBerries. One of them was a Verizon, a telephone company, in her own private name, which was not subject to, it was subject to, but never searched under, I don't think, these Freedom of Information laws. And she used the second BlackBerry to correspond with lobbyists, and lobbyists for the president of Sierra Club, and lobbyists for Siemens, who wanted to sell windmills to the government and so on. We had a lot of Gmail. A lot of government has moved over to Gmail because if somebody comes looking for the records, they won't find them. Text messaging. When Freedom of Information Act requests began piling up, they just moved over to text messaging, which is correspondence. It's on a government phone. It's to be searched and preserved. They deleted every single one of them. So it's this, they would encourage, I have a PowerPoint presentation given to EPA employees, encouraging them to tell third parties to set up AOL or Yahoo chat rooms for them to drop into, and if the other group set it up, why there was no record for the government to search, and on and on and on. They're really not that into transparency, no matter how much they say they are. And we have discovered many of the ways, certainly not all of them, that they have tried to work around their promises to work around the law. And by the way, everyone needs to know, you can turn to private assets to perform your public service, but it doesn't make the correspondence any less public. It's still ours. It's not private. And so we had an opinion in a federal court in Washington yesterday on these records. We lost. We've lost several. We're going to lose more. But you have to keep fighting because they're going to keep adapting and trying new tricks to keep, remember, records that belong to us away from us.
Thank you, Chris, for sharing these experiences with us, and thank you too.